Hello, I'm Nadia MacLeod from RP Emery Legal Kits, and we help businesses to cut their legal costs with our online template kits. Earlier this year, the Fair Work Act was changed to give employers and employees more certainty about casual employment. As part of the changes, a casual employee now has the right to become a full-time or part-time worker. This is known as casual conversion. Casual conversion is now one of the 11 minimum entitlements that must be provided to all employees. As a casual employee, you may be wondering how these changes affect you. To make a request to convert to permanent employment, you will need to meet certain criteria. Firstly, you must have been working in your job for at least 12 months. Secondly, you must have worked a regular pattern of hours within the last 6 months. And lastly, you must be able to continue to work these hours as a full-time or part-time employee. If your request for conversion is granted, you will enjoy many benefits that casuals cannot receive, such as annual leave. The new casual conversion clauses will also affect the obligations of employers. Most employers must now offer their casual workers a pathway to permanent employment. Small businesses with 15 or fewer employees are exempt from this requirement. An employer can also decide not to make an offer if they can rely on a reasonable business ground. Reasonable business grounds include the possibility that the employee's position will cease to exist within the next 12 months. If an employer decides to not make an offer, written notice of this decision must be provided to the employee. With these new changes coming into effect, there is certainly a lot to take in. However, it is important to ensure that you understand your rights and obligations under the law. If you'd like to read more about casual conversion under the Fair Work Act, please visit the link below. If you need an employment contract template, please visit our website rpemery.com.au.